afternoon, everybody. If the members would take their seats, and Sergeant at Arms will help us with the doors and crowd control. Colleagues, ladies and gentlemen, welcome back to Judiciary Committee for our Wednesday session. Let me begin by recognizing our Sergeants at Arms and thank them for their service. We have Tequila Cogdell. There's Tequila. Chris Moore. There's Chris. Gary Bridges. Gary. Terry Barnard. Sorry, Terry. I butchered it. Don't know why. And we have Michael Norton. Thank you, ladies and gentlemen. We appreciate you. We have some pages with us today. Let me introduce them. And I think y'all probably done this in some other committees. If y'all wouldn't mind, I know you've already done it before. Step up to the mic and introduce yourselves again and where you're from and who your sponsor is. And that young lady sitting on the end, she can start us off.
My name is Madison Dempster. I'm from Fayetteville, North Carolina, and my sponsor is Senator Applewhite.
Thank you.
I'm Izzy Hughes. I'm from Matthews, and my sponsor is Senator Johnson.
I'm Isabella Buchanan. I'm from Burlington, and my sponsor is Senator Gailey.
I'm Sully Ackley. I'm from Clayton, and my sponsor is Senator Sorry.
Very good. Joko.
Hey everyone, my name is Connor Schwarzkopf. I'm from Waxhaw, and I'm sponsored by Senator Lazar.
You all know who General Schwarzkopf is?
Yeah, I'm Blair Coleman. I'm from Madison, and I'm sponsored by Senator Berger.
All right, now we got a mic, so y'all speak up.
I'm Emily Berger. I'm from Reidsville, and I'm sponsored by Senator Berger.
All right. Thank you all for being here today. We sure do appreciate your service to us. I remember with fondness my time when I was a page in the House representing Chester, of all places, where I happened to meet my wife. Yeah, how about that? So we're going to start today. Representative Chester the House is in session. Is that correct, sir? All right, so we're going to skip you to the front of the line so you can do your duty in the chamber. We appreciate you being here for this. So committee will go to House Bill 612 and amendment's not ready. Okay. Senator Chester, staff is messing me up. Excuse me, Representative Chester. Staff is messing me up. They say some amendments are not ready yet. Are you able to hold with us for a little while? Okay, thank you. We appreciate it. And I'm sorry to tease you like that. So we'll go first to Senator Lazara with House Bill 247. And I think the committee should be familiar with this. And the chair recognizes Senator Lazara.
Thank you, Mr. Chairman, committee members. You'll recall this language is from Senate Bill 288, which is the Underground Utility Safety and Damage Prevention Act. This language is exactly what passed in the Senate with a couple of technical corrections. And I'd ask for your support. I'd be glad to go through it or answer any questions that anyone may have.
All right, committee, are there any questions or comments or is this all fresh in your minds from when we handled it before? All right, I don't see any, Senator Lazar. Okay. Is there anybody in the public that wishes to speak to this bill? I'm not seeing any. I don't have any on my list. We have a motion from Senator Craven for a favorable report to House Bill 247, referral to Senate rules. All those in favor, please indicate by saying aye. Any opposed? The ayes have it. Thank you, Senator Lazar. And committee, if we could, I don't know how much longer these amendments are going to be. I'll just go ahead and say we have what's that? Yeah, we have decided to, for today, displace House Bill 805. It will be brought back next week for further discussion. More things that we want to work on that on the side. So sharpen your pencils, and we'll see you on House Bill 805 next week. So Committee, if you'll please stand at ease. We're going to wait for these amendments, and we'll take up House Bill 612 in just a few minutes. Please stand at ease. That are G-rated. Senator Batch, they have to be G-rated. Okay, just as long as we're... All right, members, if you'll go ahead and take your seats, we'll go ahead and begin our process of discussing House Bill 612. So if we'll come back to order, we're back to order. Committee's back in session. Chair recognizes I wasn't sure who was going to do it. It's late in the afternoon, y'all. Thank you, Senator Blue, for appreciating the situation. Senator, you're recognized to explain the bill.
Thank you. That would be Senator Jarvis, if you remember the name. I think you had a senior moment.
Did I say that? I'm sorry. I thought I did. I apologize, Senator.
You're fine.
Steve, you're good.
I figured while we're having fun.
Senator Jarvis is recognized to explain the bill.
Thank you, Mr. Chair. Thank you, committee. I will actually just touch on some of the judiciary highlights that I see in a great foster care bill that has been a long time in the making and something that we need a reform on in this state. It requires an attorney for DSS to prepare the initial petition for neglect and abuse and dependency, and the petition alleging interference with an assessment. It adds the ability for the DHHS prosecutor to review a DSS's decision to not file a petition. It also creates a procedure where DSS must try to refer a case anytime there's a conflict of interest, and if they are not able to do so, DHSS is able to intervene. It clarifies the intervention of abuse, neglect, and dependency of actions that can occur both with the caretaker and the foster care parent. It clarifies after hours petition requiring a judge or a magistrate to be available at all times. It also has that a judge or a magistrate is the one to make a non-secure custody order. It fills the gap in current law where co-guardians are appointed if it's a permanent appointment plan, and in areas of where there may be a divorce or something may happen with that, it defines what the remedy the court may order. It also removes automatic appointment of Rule 17, which is the guardian ad litem for a minor, and gives the ability to choose 16 or 17-year-olds in that case. It also requires DSS to be represented by an attorney, and that attorney have additional training. It It also says that DSS observes and will supervise visits before unsupervised visits or return home in the place of foster care. It requires an order approving unlicensed placement with someone that is not a relative kin, not a relative, if the child is being placed where maltreatment can be occurred. It has to be an order approving that placement. It also makes clear that DHHS can assess child protective records to review in the case where DSS they think that there's procedures or processes that DSS is not taken care of properly. DHHS at the state level is able to step in. It also allows voluntary mediated post-adoption contract agreements between parents and prospective adoptive parent only in cases where the juvenile is in DSS custody pursuant to an order entered into by abuse, neglect, or dependency case. And it also establishes the process to remove an individual from a responsible individuals list. And with that, the Part 2 and Part 3 is House Bill 795 that passed the House unanimously. It expands guardianship assistance program eligibility for 10-year-olds in foster care to where they can receive child support and move on up into, if they go to college, I believe through 21, if I'm not mistaken. Part 3 incorporates House Bill 182 that passed unanimously in the House, which relates to felony child abuse, child torture, and creates no permanent contract order for the violent offenders and the family. So it extends it to the family as well as the offender. Part 4 incorporates all of House Bill 162, which requires counties and cities to conduct a criminal history record on anyone that will be taking care that are going to be hired for positions handling children and taking care of children in that way. And at this time, Mr. Chairman, I think there's an amendment available.
Thank you, Senator. I believe that we have a question about one of the amendments. Senator Gailey, I believe you're going to send forth the amendments. Is that right?
Yes, Mr. Chairman. I prefer, with the chairman's permission, to send forth first H612 ACI-31 version 3.
Okay. Thank you, Senator Gailey. Has sent forward her amendment, and she's recognized if she wishes to explain the amendment, or would you prefer the bill sponsor to explain it?
I can explain the amendment. It's technical in nature. It's to clear up some drafting changes that are necessary, just to clean up the language. If there's anything other to say about it, I defer to the staff.
Okay. Thank you, Senator. Are there questions about the amendment from the committee members? I'll give you a moment to digest it since I know everybody just got it. Any questions about the amendment? Going once, going twice. There being no questions, this would be 31 ACI 31 version 3. We'll stand at ease for a moment and make sure all the members have copies of the amendment. We'll defer to his co-chair and make sure he's had a chance to peruse the amendment before we take a vote. See if he has any questions. Senator Daniel, do you have any questions about the amendment? Oh, I thought you, never mind, I thought it was. Before I come back to Senator Daniel, is there anyone else that has a question about the amendment?
Mr. Chairman,
Senator Gelly, you recognized.
just ask Senator Daniel to double check that he's looking at, because the amendment that's before the committee now doesn't have any print on the back page, and I'm not wearing my glasses, so but you have the, no, it's just make sure you're looking at ACI-31 version 3.
Yeah, it's only 2 pages. Well, stand at ease. I apologize that we're in this position. Amendments arrived late, and we haven't all had a chance to review, including the chairs, so we'll stand at ease for just a moment. All right, committee, thank you. Thank you for your patience and indulgence. To be clear on the record, Senator Daniel, do you have any questions about the amendment before us?
Not this one.
And that is, with the amendment before us is ACI 31 version 3. All right, there being no questions from the committee, all those in favor of the amendment, please say aye. Aye. Any opposed? The ayes have it. And the bill as amended is back before us. I believe there's a second amendment. Senator Galey?
Yes, Mr. Chairman, I'd like to send forth a second amendment, which is not technical in nature.
All right, state your amendment.
Okay, I believe the amendments before the committee, it is ACI-30 version 15. This amendment removes language in the bill that removes certain language before on mental health evaluations. So we will be restoring the law so it would remain as it is. Second, it changes the Rule 17 guardian ad litem section, which I believe this is on the second page of the amendment, starting on line 7. So instead of just having a blanket saying that a parent who's under the age of 18 doesn't get a guardian ad litem unless there's a reason other than the age that they need a guardian ad litem, this would appoint Rule 17 guardian ad litem to all parents who are under the age of 16. Then on the motion of any party or on the court's own motion, the court would appoint a Rule 17 guardian ad litem if the parent is either 16 or 17. So we understand that there may be times where the parent is mature enough to participate fully in the proceedings and not want a guardian ad litem, but this would maintain the ability for the court to appoint one if it's necessary. It removes the repeal of General Statute 7B-906.2D, which details findings of facts for a judge to make about the success or failure of a parent's reunification efforts. Then the amendment makes changes to the bill's modifications of child support. Under section 1.13, the bill would still allow the court to use discretion to order child support when it's in the best interest of the child. Related but unamended is section 1.21A, which notes that any unpaid child support while a child was under the care of DSS will not result in an arrearage against that parent. But it does remove section 1.21B, which aligns with changes made in section 1.13. And the reason for this change is it was brought to the attention that payment of child support may be one consideration that a district court judge would want to have in deciding whether or not a parent has really exercised all of their best efforts in reunifying with the child and resolving the issues that are before the court. Furthermore, the amendment removes section 15A, which is related to adoptions with the father's consent, and removes all the section 14C changes related to father's consent. This is a complicated policy decision. After some really interesting feedback from some folks with the courts, we determined that in the area, of course, in child welfare, it's best to move very carefully so we don't have unintended consequences. We don't need to change the statutes to help a putative father when he's made efforts. A trial court can make a decision based on the facts and the credibility of the witnesses before them. So whether or not a father has made best efforts, it's best not to put a time clock on that father, but to allow the court to have the discretion to weigh the relative, the value of the different witnesses before it and their credibility. So we would like the courts to continue to work on this issue. Other clarifying changes that align with the intent of the bill is to ensure one standard of proof for the responsible individuals list expunction process. We also update the effective date for requirements of legal counsel to be effective immediately, and then the implementation date to April 1st, 2026. And then it clarifies when either the division or the district attorney's office shall investigate, but it doesn't change the requirement for either agency to notify each other. So that's a lot to digest. This is a lot of changes to the bill, Mr. Chairman, and I'm ready with other committee members to answer questions if necessary.
Thank you, Senator Galey, for that explanation. You're right, it is a pretty substantive amendment. Before we go to the other committee members with questions, do the bill sponsors have any comments that they would like to make about the amendment?
It's a friendly amendment. I believe We believe it makes the bill stronger in the way it is, and we support it.
Okay, thank you. Thank you, Senator Jarvis. Questions from the committee? Okay. There not being no questions, all those in favor, please say aye. Any opposed? Ayes have it. Bill is amended, is back before us. Senator Jarvis, Representative Chester, you're recognized for any further comments on the bill. Okay. All right. There's a lot. Are there more questions from the committee with the bill as amended? Is back before us. More questions or comments? All right. Not seeing any. I know we do have some people in the public who've signed up to address House Bill 612. So we'll start on that and we'll hear from them. I have two people on the list. It looks like we only have two. So if I think I'm reading the handwriting right. It looks like Jamaica Pfister is signed up, and after that is Tammy Fitzgerald. And so if we only have two speakers, we'll recognize you for about 2 minutes, Ms. Pfister. Please state your full name and who you're with. Thank you.
I'm Jamaica Pfister. I'm with Children's Home Society of North Carolina. I'm the Director of Government Affairs there. And I'm here to talk about the child welfare pieces of HB 612. Children's Home Society is one of the largest private nonprofit child welfare agencies in the state. We partner with DHHS and county DSSs to provide child welfare services to all 100 counties and serve about 25,000 children and families each year. The child welfare system is a complicated but very necessary system, and we applaud the bill sponsors and all the staff that have spent a lot of time working on this bill. There are a couple of changes that we feel like will strengthen the system. In particular, the strengthening the oversight that DHHS has will help more consistency from county to county. The ability of judges to appoint co-guardians offers an additional permanency option for youth in care. Preventing youth from being placed in unlicensed facilities will ensure that those youth are safe while they're in foster care. Requiring court hearings in certain situations when there's a proposed change in placement will allow caretakers to be heard in court and lead to more placement stability. The reforms around mental health hospitalizations will ensure that youth are receiving appropriate care and appropriate placements when they're discharged from the hospital. Decreasing the age requirement for youth that get KINGAP funds will allow more youth to reach permanency and provide necessary financial support for their caregivers. While there's still a lot of work to be done in the child welfare system to better serve the families and youth that are involved, we thank you guys for all of the work that you've done for these changes.
Thank you for that. Next we have Tammy Fitzgerald.
Good afternoon, members of the committee. Thank you for bringing this great bill to the legislature, and we want to thank the sponsors of the bill for working to speed up permanency for foster care children and all the great provisions in the bill. And we thank you for fixing a few provisions on adoption. Apparently, I've still got to read it all and digest it, but thank you so much for your good work on this bill. I know that Senator Jarvis, you especially been working on this for a long time, so thank you both, Representative Chesser and Senator Jarvis.
Thank you, Tammy. Thank you, Ms. Fitzgerald. Are there any other members of the public that wish to address this bill? I'm not seeing any. Any further comments or questions from the committee? We have a motion from Senator Lazara, and that motion is for a favorable report to House 612 as amended, rolled into new PCS, unfavorable to the original bill, with a referral to Senate rules. All those in favor, please indicate by saying aye. Any opposed? The ayes have it, and the bill passes. Thank you, gentlemen. And that concludes our agenda for today. This committee is now adjourned.